This is Paul Turner, the Immigration Barrister at Imperium Chambers. Two issues, or one related issue but covering two different matters, which is the right to work and the 3225 Balajigari litigation. Now, in particular, what I want to talk about is the right to work and the apparent discrepancy between those that have got judicial reviews or matters in the Court of Appeal and those that have been granted statutory appeals. And are they being treated the same? The short answer is no. I'll explain why and why I think it's unfair. Firstly, it's accepted by the Home Office that those that are in the Balajigari cohort, which includes judicial reviews and matters in the Court of Appeal, pending reconsideration of their application, which is generally a CETO application, should be given or will be given the right to work if they write to Capital House in Liverpool. All well and good. Now, in the same vein, I've written a number of letters, and I've received one in response to individuals, or an individual who has a right of appeal, a statutory right of appeal, not a judicial review, a statutory right of appeal, asking for that individual to be given the right to work. And the Secretary of State's response is, you are not in the Balajigari cohort of cases, and therefore you're not entitled to the right to work. Now, these are individuals that have previously had maybe a CETO application refused, admin review refused, chose not to go down the judicial review route, and rather made a CETLR application which carried with it a right of appeal. Now, the reason the CETLR application was refused was on the same basis, i.e. paragraph 3225. So currently it appears, and this video is really to elicit a response or to see if other people have experienced the same thing, those people that had a CETO and went straight to JR are allowed to work even though they don't have any leave at all in the United Kingdom, whereas those people who had a CETO application refused, then made a CETLR application and were given a right of appeal, are not going to be given the right to work unless they win their appeal. Now, if you can tell me why that makes any sense, given that both refusals are predicated upon 3225, then I will be greatly indebted to you. But I don't see that there is a lawful or justifiable reason for separating out those that have gone for JR and those that have gone for a further application but been refused essentially for the same reasons. It seems to me that they should all be treated the same. Perhaps the way forward is for the matter to be progressed by way of a court case, and that's something that I'm going to consider. But I'm interested to see whether other people have experienced the same thing and whether other people who have made statutory appeals have actually been given the right to work, or whether the Secretary of State is seeking to hive off and separate the Balajigari, JRs and Court of Appeal cases from the statutory appeals. It's particularly troubling given that individuals have been in the United Kingdom often for very many years, from 2016, without the right to work or without any form of proper settled status. And this obviously puts a great deal of strain on them and their families, and has often led to people making voluntary departures, which the Secretary of State seizes upon as an excuse to not allow them back into the country. So having forced them out doesn't give them the opportunity to then answer any concerns, which I touched upon in a previous video. This is a short video. It only really concentrates on the apparent unfairness between those that are appealing on the basis that they shouldn't have been refused under 3225, who are not allowed to work, and those that judicially reviewed 3225 refusals, who are allowed to work. I'd be interested in getting some feedback from people that watch this video, and potentially if anyone has an interesting case, I'd be interested in running it, because I think that this is grossly unfair and it's something that ought to be addressed, and it's probably only going to be addressed through the courts given the Home Office's position as it appears to be at the moment. Thank you for watching this short video. If I have any further updates or I get the right to work for any people with statutory appeals, I will of course update you. The right to work is obviously an important issue and something that I'm looking forward to working with the people from the Right to Work Limited Group, and they're meeting in Birmingham later this month. This has been Paul Turner, the Immigration Barrister at Imperium Chambers. Thank you for watching.